Okay, this is CR 2020-5981, State of New Mexico versus Eleanor Carlton. Entries, please.
Good morning, Your Honor. Nicole Sanchez on behalf of the City of Albuquerque.
Thank you. Thank you. And Mr. Tapia, please pull the microphone towards you. Put it in a place where it can, you could, yeah, make, yes, yes, make sure, yes. Because the masks really muffle us, and it's hard for me to hear clearly, and we want the monitors to pick us up, even though this is a non-record case, we still want the monitors to pick us up. So, we are set for a bench trial this morning. Is the city ready to proceed?
Yes, Your Honor.
Okay, Mr. Tapia, did you have some pretrial motions?
Well, I want to move that all my previous motions be considered, and I also had a motion to...
Okay, I need to know specifically what you mean, Mr. Tapia.
The motion to dismiss, a motion for against the use of the statute of limitations. And we have a witness in here, Your Honor. Are you invoking the rule?
Yes. I wasn't sure if we were...
Okay, well, I was going to hear pretrial motions now, but let me... Mr. Tapia, but you're saying you're renewing your previous motions that you made. You said your motion to dismiss. What else?
The statute of limitations having run. And that's it, Your Honor.
Okay.
Well, I did have a previous motion. The court denied our stipulated motion to have the case recorded. And then I talked to your secretary yesterday. She emailed me and said you would entertain this morning a motion to have a court reporter present for the hearing.
Okay, what I told my secretary was that you could make that motion this morning. I didn't want to have an ex parte communication with you, so you had the option of filing that motion in writing or making that motion orally today. And so, first of all, regarding your motion to dismiss and your motion regarding the statute of limitations having been run, the court has already heard those motions previously and already made rulings on those. So my rulings stand on both of those issues. So I had previously denied your motion to dismiss, and I think that was a general motion, and then your motion to dismiss because the statute of limitations is run. I also denied that motion, and that was under statute -30-1-8, section 8. We went over this before. I'm just going to pull it up again. Under 30-1-8, time limitations for commencing prosecution, under section H, it says here, a person shall not be prosecuted, tried, or punished in any court of the state unless the indictment is found or information or complaint is filed within the time as provided. Under H, it says for any crime not contained in the criminal code or where a limitation is not otherwise provided for within 3 years from the time the crime was committed. So that is the statute that I'm relying on for denying your motion to dismiss. This charge is under the Uniform Administrative Code, and so the statute of limitations is 3 years instead of 1 year, as you had previously argued. So I'm denying that. So what other motions did you have, Mr. Tapia?
Before we get on that, on 31-8, which paragraph did you do, C?
H.
H, okay. Well, I want to raise the motion again.
Okay, I've already heard,
all the motions you've denied me, but I want to raise it just... Okay,
go ahead and make your motion then, briefly, please, and then I'm going to allow the city time to respond.
Well, just on the end, we requested the name of the person that made a quote, anonymous call to the city, and we still haven't received it.
Okay, and I believe we had a hearing on that. We addressed that issue already. So are you telling me that you're renewing that motion as well?
Yes, sir. Yes, ma'am.
Had a hearing on that already, Mr. Tapia, and I stand by my ruling. I heard argument from the city. I heard from you as well, and you were moving to require the city to disclose that person. The information that came out at that previous hearing was that the city didn't have, they only had a phone number and they weren't willing to disclose that, but they didn't have a name to provide because the log that they had didn't have a name on it, I think is what it was. And even if it did, I think their argument was that they don't disclose the names of anonymous callers. So, but we had already had a hearing on that. City, did you want to respond?
No, Your Honor, you summarized our point of view and that it would fall under the informant privilege.
I'd like to remind the court of the Sixth Amendment right to confront the witnesses, and that's paramount in a criminal case. It's not this is in a civil matter.
Okay, and your objection is noted, Mr. Tapia, but we'd already had a hearing on this issue. I wasn't planning on rehearing issues that I already made rulings on. Okay. Okay, any other pre-trial motions, Mr. Tapia?
Your Honor, I attempted to find a court reporter, and I couldn't, to have on standby because I didn't think the court was going to grant a continuance so that we could transcribe the case. And I just got a call, because I just called back this morning to see if there had been a cancellation on the other events that they were transcribing, and there had not been. So I do not have a court reporter ready and available for today.
Okay, but you were wanting to request to have a court reporter present to transcribe the trial today. Okay, is that still your request? Okay, let me hear from the city on that.
The city doesn't oppose having the hearing recorded. However, I don't think that a continuance would be appropriate in this case. We're ready to move forward. This case has been going on for quite some time. We'd like to proceed.
Okay, and like I said, Mr. Tapia did talk to my secretary yesterday and asked if he could have a court reporter present, and I said that I wouldn't hear that until this morning. Mr. Tapia, I am going to deny your oral request for a court reporter to transcribe this trial. This is a non-record case, and as such, let's see, this case can be appealed, and a de novo trial would be granted at district court. The law does not provide for a transcript, including a tape recording or stenographic transcription of a non-record case that's at trial in Metropolitan Court. And if I were to allow you to have a court reporter present to transcribe this, it simply is not appropriate in this case, Mr. Tapia, and I'm not going to allow it. If you decide to appeal this case to district court, you would get a brand new trial in this case. I don't know to what extent they would look at the record. They might look at filings, or they may just grant you a brand new trial. So with that, this request was not made in writing to the court, and it was made just yesterday through my secretary. You did have the option to make that request, Mr. Tapia, at an earlier date and in writing, and giving the city a chance to respond. And I did call the legal department and ask if that was something that I could allow, and I was told no, that it's not. This is a non-record case, and so that could not be allowed.
I noticed yesterday or the day before that the court had issued the order denying the stipulated motion to have the case recorded through the Metropolitan Court methods that you use.
And I
got that 2 days ago, so that's why I thought of some other idea.
I understand what you're saying. There was returned mail because the suite number was left off of your address, but it was still, that order was still uploaded into the Odyssey system. So, you could have called back to inquire about that, or it was available on Odyssey, the denial of the request to have the, to bring in a video recorder or some kind of recorder to record the hearing or the trial. So, do you want to make any further argument, Mr. Tapia, regarding that?
Your Honor, we did not have the notice. We don't have the duty to go looking on Odyssey every time something's filed. There's a method by which either it's mailed correctly or it's emailed. Yesterday I got the email, and that was fine enough. And since the city had stipulated to the recording before, I didn't think it would be an issue. So I wanted to know.
Well, even if the court was not going to be able to grant that request either way, Mr. Tapia, because we just don't allow that recordings, because it's a non-record case, we can't allow that. So how does that prejudice your client, Mr. Tapia?
Well, she has rights. We are in the, where she can request things, and it doesn't hinder if she was going to pay for the transcriber. And she wanted a copy of the proceedings, and it prejudices her in not being able to review the proceedings for a subsequent trial. And I want to object to the court saying we can appeal it. Does that mean the court's already made up its mind?
No, I'm saying there's an appeal process. There's an appeal process that allows for, well, this is simply, it's a non-record case, and there's an appeal process where it would be a brand new trial, and that's how non-record cases are handled. There's not a transcript, and there's not a recording of the hearing. It simply doesn't happen for non-record cases. We only have audio recordings for record cases, which are DWI cases and domestic violence cases in this court. So those are the only instances in which a recording can be provided to parties.
Thank you, Your Honor. Thank you. I'd like to just state it for the record so that we can maybe make new case law. Thank you.
Okay. Anything more from the city? Okay. The court is going to be entering an order denying defense's oral motion. I had that prepared so that I could make sure that that's in the record once I heard from both sides. Okay, and so if we're ready to proceed, Mr. Tapia or City, are you invoking the rule?
Yes, Your Honor.
Okay. Any other pretrial motions, Mr. Tapia, besides the ones you already made?
No, Your Honor.
Okay, does the city have any pretrial motions?
No, Your Honor.
And is the city ready to call its first witness?
Yes, Your Honor.
Okay, and who is the city going to call?
Deborah Rowley.
Okay, and sir, you're a witness, right? You'll have to, since the rule has been invoked, you'll need to step outside the courtroom. You'll need to sit in the hallway until you're called. Okay, thank you.
I'd like Ms. Rowley to...
Yes, please come up to the witness stand, Ms. Rowley, and I will swear you in. Please raise your right hand. Do you swear and affirm that the testimony you're about to provide to the court is the truth under penalty of perjury? I do. Okay, please have a seat. Make yourself comfortable. Make sure the microphone is close or that you speak up.
Morning, Ms. Rowley. How are you?
Good morning. Well,
Thank you. Will you please state your name and title?
Deborah Raleigh, Chief Building Inspector for the City of Albuquerque.
And where do you currently work?
I work at City of Albuquerque.
And what was your previous position?
I was the Building Complaints Investigator for the City of Albuquerque.
How long were you the building complaints investigator?
I started with the city in that position in August 3rd of 2019. And I became the Chief Building Inspector June of 2021.
And as the building complaints investigator, what were some of your duties?
When we received calls or complaints were filed, we had to investigate whether the property had proper permits for the building work going on.
So as a part of your duties, you conducted inspections?
I did conduct inspections.
And as a part of your inspections, did you take photographs?
I did take photographs.
Okay, thank you. Are you familiar with the Uniform Administrative Code?
I am.
And how are you familiar with that?
This is the code that governs our rules and regulations for the City of Albuquerque.
Are you familiar with the property located at 518 Valencia Drive Southeast?
Yes, I am.
And how are you familiar with this property?
We received an anonymous call that there was some building work going on the property. I did look into whether permits existed on the property before going out to investigate.
And hold on one second, Ms. Sanchez. Okay, I'm just trying to catch up. Go ahead.
Do you know who the property owner is?
Miss Carlton.
And how do you know that?
I only knew that after I went to the property to conduct an investigation, and the workers told me that I only knew her by Jane. And then once Miss Carlton called me later that afternoon, she gave me her full name.
Are you familiar, do you know that she's a property owner through any other way?
No.
Okay. Your Honor, please forgive me. I have Plaintiff's Exhibits 1 that are currently marked. Would you like me to put a sticker on them?
Yes, do you have some there?
Yes, I do.
Yes, please mark the exhibit, and were those proffered to defense as well?
Yes.
Okay, and you can show that to Mr. Tapia before you review that with the witness.
Would you like yours with a sticker?
If you can just show it to him, he can just take a look at it, and then you can take it back.
And Your Honor, I provide this to you?
Not yet, not until it's been published, until it has to be, the foundation has to be laid, and, it has to be admitted into evidence first. But,
yes, you can have that one.
Okay.
So I handed opposing counsel Plaintiff's Exhibit 1. May I approach the witness?
Sure.
Ms. Rowley, I've offered you what has been marked as Plaintiff's Exhibit 1. Do you recognize this exhibit?
Yes.
And what do you recognize it to be?
This shows the ownership of 518 Valencia.
Section that's hearsay, improper foundation.
Your Honor, this is a public record provided by Bernalillo County's Assessor's Office, and if I may ask a couple more questions of Ms. Rowley, we will authenticate that.
Okay, so Mr. Tapia, I'm going to deny the objection at this time. Ms. Sanchez is attempting to lay the foundation for this document first before it's admitted into evidence. So the court's not going to allow it into evidence unless and until she's laid the proper foundation. Okay.
Ms. Rowley, where did you first see this document?
We ran this report through Bernalillo County website to find ownership of, not find ownership, I knew who she was, but to verify that she was the legal owner of the property prior to any legal notices being sent to Ms. Carlton.
And is this a public record search that is accessed through Bernalillo County Assessor's Office?
Yes, it is.
And I notice at the bottom there's a website. is that the public website to access property ownership information?
Yes, it is.
Okay. So, Your Honor, I offer Exhibit 1 into evidence.
Okay, defense? Okay, city, do you have any?
This is a public record.
Okay, and so, Mr. Tapia, what's your,
What's the point? The point is,
what is your response to this is a public record and you're objecting to this being admitted into evidence? What's the basis for your objection?
thank you, Your Honor. The basis of my objection is the witness testified that she hadn't had any other knowledge except for what was told by these people. Now they're trying to shoehorn in this exhibit to say, oh yeah, this is how we do it, and it is public record. The testimony before the court is that she found out through the workers that were there, and that's honest and that's good enough. We don't need a public record to go in because we know it's on the computer and everybody can get it. But the statement made by the witness is that she didn't have any access to anything except statements made by the people and by Ms. Carlton attempting to meet with her and calling her.
Okay, but what is the basis of your objection for this being, Ms. Sanchez stated that they're entering this as a public record. What's your basis for objecting to it being entered as under that basis as a public record?
But what's the relevance or the materiality? She said she didn't look at it, she didn't see it. What do we need it in the record for?
Ms. Sanchez?
Am I allowed to ask the witness an additional question?
Yeah, I think, so you can still continue to lay the foundation if you believe additional foundation needs to be laid.
I would like to ask one more question,
Okay.
Ms. Rowley, if that's appropriate.
Sure.
Ms. Rowley, how did you find the mailing address for the property owner?
It was through the public record on the website for Bernalillo County.
And
We have to verify that before sending out any legal notices. So I did this research prior to the legal notice being sent out after I met Ms. Carlton at the property.
Thank you. So this is the name and the address you used to send the notice of violation?
Yes, it is.
Okay. Your Honor, so the reason this is relevant is because it is a public record that identifies the property owner of record and gave Ms. Rowley the correct ownership information and mailing address to identify the defendant.
Hold on one moment. Okay, anything else from defense? Okay, I'm going to deny the objection to this exhibit number 1 being admitted into evidence. I believe Ms. Sanchez has laid a proper foundation, asking Ms. Rowley if she recognizes the document, knows what it is, and how she had access to it. And I believe it is relevant. It is relevant to ownership of the property, and public records are self-authenticating as well. And so I'm denying the objection, and I will allow the city to enter city's exhibit number 1. Yes. Are you asking to publish that document to the court? Okay, sure.
I continue with questioning the witness regarding this document.
Sure, yes, go ahead. I'm just going to stick this exhibit here if you need it again.
So, Ms. Rowley, in looking at Exhibit 1, can you tell me the name of the owner?
Carlton Eleanor Jane, trustee, Carlton, RVT.
And what does it say is the location address?
It is 800 Valverde Drive, Southeast, Albuquerque, New Mexico, 87108.
So that's the owner's mailing address, correct?
Yes, correct.
And so I'm asking, what is the property identified as the location address that Ms. Carlton is the owner of?
That would be 5.
Hold on, there's an objection.
misleading.
I'll restate the question.
Okay, please restate the question.
Ms. Rowley, what is the address of the property at issue in this, report?
518 Valencia Drive Southeast, Albuquerque, New Mexico, 87108.
Thank you. And you used this information to provide the notice of violation, correct?
Correct.
Okay, thank you. So when did you first go to 518 Valencia Drive Southeast?
I visited the property on August 18th of 2020.
Did you go any other time?
On August 19th, 2020.
And why did you go on August 18th, 2020?
We received an anonymous call through our 311 hotline, and I have to verify if work was going on, if what was reported was correct. So I did visit the property on August 18th.
And what did you find when you went there?
Walked up to the property. There was lots of construction debris in the front of the property. I walked up to the front door and knocked on the front door. Two workers, in fact, came out. They walked me back down the steps. There's 3 steps going up to the front door. They came out and the door went forward, so I had to back off the front porch. I asked them if they were the property owners. They said no, they were not. I asked if I could contact the property owner. They said her name was Jane and she would contact myself. I had let them know that the work they were doing, I wasn't sure if a permit was needed, so I needed to do an inspection of the property, and they denied me access to the property. So I therefore left a notice asking them to stop work until the property owner could contact me and I could get an interior inspection.
Thank you. And did the property owner contact you?
Ms. Carlton contacted me that afternoon.
And what did Ms. Carlton say?
She...
Hold on a second. Your response?
This is an opposing party statement?
Okay, the objection is, do you want to make a further basis for argument for your objection? Okay, I was going to deny the objection. Okay, go ahead.
So you can answer the question. What did Ms. Rowley say? What did Ms. Carlton say when she called you?
She identified herself as the property owner, introduced herself as Jane Carlton. She told me it was her property. She asked me why I needed to look into the property. I explained to her it was turned in. There was building going on without permits on the property, and I believed that there was work that needed permitting. And I said I could meet her at the property. We could discuss what needed permits, what did not need permits. She agreed to let myself and my supervisor do an interior inspection, and we arranged to meet there on the 19th.
So
Hold on 1 second.
Yes.
Let me just catch up a little bit here.
Absolutely.
Okay, go ahead.
So what is the building inspector's authority for right to entry a property?
We are given authority under the building official of the city of Albuquerque, under the UAC Administrative Code.
Your Honor, I would request your guidance with this exhibit. I do have a copy of the Uniform Administrative Code, the 2018 Administrative Code, that was part of the defendant's exhibit. Would you like me to enter this exhibit as well, or is it considered with judicial notice since it's an existing administrative code?
I don't think it necessarily needs to be entered as an exhibit. It's the law governing this case.
Okay.
And so I don't think it needs to be entered, and I do have a copy of it here in front of me, so I'll allow you just to proceed. Does the defense want to add anything, or?
It is marked as Carlton 27.
Oh, I marked.
Yes. So out of the 2018 Uniform Administrative Code, Defendant's Exhibit, page 27, identifies Section 105.4, right of entry. Your Honor, may I approach the witness with this
Sure.
provision?
Sure.
So, Ms. Rowley, do you identify this as part of the Uniform Administrative Code?
Yes.
And would you please read Section 105.4, right of entry?
The whole paragraph? It reads, whenever necessary to make an inspection to enforce any of the provisions of this code, or whenever the building official or his authorized representative has reasonable cause to believe that there exists in any building or upon any premises any condition which makes such building or premises unsafe as defined in this code, the building official or his authorized representative may enter such building or premises at all reasonable times to inspect the same or to perform any duty imposed upon the building official by this code.
Ms. Rowley, did you find it necessary under this section to make an inspection at the property?
Yes, I did.
Why did you find it necessary?
We were reported there were building violations were occurring, and I found no building permits on record prior to going to the property.
Thank you. Did you have reasonable cause to believe that there might be an unsafe condition at this building or on the property?
Due to the debris that was there and not being able to do an visible inspection on the interior, anytime there's construction work going on and there is no permit, a permit is what keeps the public safe, a life safety. So without that inspection, we do consider it unsafe work.
So you said on August 19th, 2020, you met Ms. Carlton at the property to conduct an inspection, correct?
Yes, I did.
And did Ms. Carlton give you consent to inspect the property on that day?
Yes, she did.
And tell me about your inspection on August 19th, 2020.
I met Ms. Carlton along with my supervisor at the property. Ms. Carlton opened the door and let us enter the property. She walked ahead of us, showing us around the property.
And what violations did you observe?
To the west end where the bathrooms were located, there was some plumbing work that had been done, a new installation of shower valves. There was a shower enclosure. When you replace shower valves, it's required to have a plumbing permit. Then we walked to the back of the property, through the kitchen. There were down to the north side, the addition or the garage had been turned into a room at some point in time. There was a water heater and there were gas lines installed there for a dryer as well as a new water heater being installed.
And did you inform the defendant of the violations at the time of the inspection?
I did. I asked Ms. Carlton about it. She said she had had 2 new gas lines installed, one for that unit and one for the back unit for the dryers, and that she was in the process of, there were parts there for the water heater. It hadn't quite been done yet.
And do these violations that you mentioned require a permit?
They do require a permit. They require a mechanical and plumbing permit.
Your Honor, I would like to mark plaintiff's exhibits 3, 4, and 5, which are all the notices of rally provided Ms. Carlton. Would you like those each marked separately?
Yes, please, and, on your exhibit list, which ones would those be?
3, 4, and 5.
Okay, so that's red tag notice number 1, red tag notice number 2, and a pre-criminal summons notice?
Yes, Your Honor.
Okay, and Mr. Tapia, have you seen these? Okay, and Ms. Sanchez, if you can just show those to Mr. Tapia again, please.
Your Honor, I've handed opposing counsel a copy of Exhibits 3, 4, and 5. May I approach the witness?
Yes.
Ms. Rowley, I've handed you the exhibits that are marked as 3, 4, and 5. Let's start with the one that's marked 3. Do you recognize this exhibit?
Yes, this is the notice, the first notice I sent to Ms. Carlton.
And what's the date of the notice?
August 19th, 2020.
And who did you address it to?
Eleanor Jane Carlton, trustee Carlton, RVT.
And where did you get this name and address?
This was found on the Bernalino County ownership site.
Thank you. And what is the property where the violations were cited?
This was at 518 Valencia Drive, Southeast Albuquerque, New Mexico.
And tell me what this letter provides.
This provides Ms. Carlton all the violations and under what codes we cited for these violations.
So on page 3 of Exhibit 3, will you read the violation description?
Windows, a re-roof TPO, new water heater, new gas lines for dryer, new plumbing and bathrooms.
Your Honor, we would like to offer Exhibit 3 into evidence.
Okay. City, what's your response to the objection that it's hearsay?
Ms. Rowley has knowledge of this document, and it is also a public record.
Okay, and this is a red tag, the first notice, right? You're saying that's a public record?
Yes, under the Inspection of Public Records Act, it's considered to be a public record. And this is a letter that Ms. Rowley herself wrote to Ms. Carlton.
Okay, and Mr. Tapia, any further objection?
The IPRA Act is for the state divulging what is in their records. It is not to be used in a court of law against a citizen accused as an excuse to make anything available to be admitted into court. I still stand my objections that it is hearsay. A red tag is not public record unless you go and ask for it. So it's not a public record until there's an IPRA request made, and we didn't make one.
Ms. Sanchez?
This document is relevant because it provides notice to the owner of the violations.
Okay. I'm sustaining the objection only unless and until the city can lay additional foundation. I think if this is a public record, I haven't heard sufficient foundation for it yet.
Essentially, Ms. Rowley has knowledge of this record.
Okay, so why don't you ask Ms. Rowley some questions, foundational questions, so that we, you can attempt to lay the foundation for this record.
Okay.
So is your argument that it's a public record or that it's a business record? Because you said that she made this document herself, right? So what's your argument, that it's a public record or a record of regularly conducted business?
Well, since this record would only be public if it was requested by an individual, I will say that this is Ms. Rowley's business record in her course of business as a building inspector, and she wrote this letter and kept this letter in her records, and it is being used for the purpose of providing documentation of the notice provided to the owner of the violation.
Okay, and so I think the proper foundation for records of a regularly conducted activity, that foundation needs to be laid. So that's what I need to hear.
Yes. Ms. Rowley, did you write this letter at or near the time that you conducted the inspection?
Yes, I did. I wrote it the afternoon after the inspection on August 19th, 2020.
Is this a letter that you keep regularly as your position of a building compliance investigator?
Yes, this was a letter that's written to properties when they are in violation, making them aware of the violations and under what codes we can enforce for them to correct these violations for the properties.
And is making this record or this letter a regular part of your job description?
Yes, this is.
Your Honor, I offer Exhibit 3 into evidence.
Okay, Mr. Tapia, I believe I've heard the proper foundation for a record of a regularly conducted activity, and unless you have an objection, a specific objection that something has not been met for the foundation for this exhibit.
Fine. This is a copy of something out of a record. It's not a copy of what was sent to the individual.
Okay, so what's your objection?
That it's not an accurate, fair representation sent to Ms. Carlton.
Okay, Ms. Sanchez?
Best evidence.
Ms. Rowley has already testified that she wrote this letter, and we could ask Ms. Rowley why it was not signed, but Ms. Rowley's already testified to her knowledge about this letter.
Okay, and under the hearsay objection for records of a regularly conducted activity, the foundation has been laid. The record was made at or near the time or from information that was transmitted by someone with knowledge, so that was met. The record has been kept in the regular course of activity for Ms. Rowley's position, and it was a regular practice as she testified, and so I believe she has met the foundation for record of a regularly conducted activity. So I will allow exhibit number 3 to be admitted into evidence over defense's objection.
Ms. Rowley, on page 3 of exhibit 3, will you please read the violation description?
Violation description was new windows, a re-roof TPO, new water heater, new gas lines for dryer, new plumbing and bathrooms, without permits, inspections, or approvals.
And what is the violation or the code description?
This falls under the Administrative Code 109.1. Like me to read that?
Yes, please.
109.1 reads, permits required, exceptions as specified in sections 109.2. No building, structure, or building service equipment regulated by this code and the technical code shall be erected, constructed, enlarged, altered, repaired, moved, improved, removed, converted, or demolished unless a separate, appropriate permit for each building, structure, or building service equipment has first been obtained from the building official.
Did you send this notice?
I did send this notice.
And, did Ms. Carlton respond to this letter in any way?
She did. She called. She also wrote letters to me, as well as text.
And, did Ms. Carlton say that she was going to get a building permit for these items?
She wanted to know further information. She did come into the building to start the permit process. It only started in draft, and then she never followed through with anything.
Okay, Your Honor, I would like to now turn to Exhibit marked Exhibit 4. Ms. Rowley, do you recognize Exhibit 4?
Yes, this was the second red tag notice sent to Ms. Carlton.
What is the date on it?
September 22nd, 2020.
And,
I'm sorry, what was the date again?
September 22nd, 2020.
Okay, thank you.
And did you write this letter?
I did.
Is this a letter that you typically write as a building compliance investigator?
Yes, this is the second process in our trying to gain compliance for violations.
And is this a letter that you keep in your records?
Yes.
Your Honor, I would like to offer Exhibit 4 into the record.
Mr. Tapia? Okay, what's your objection?
Hearsay.
Okay, Ms. Sanchez?
This is an exception to hearsay, that it's a record in the regular course of business as a building compliance investigator.
Okay, and I believe the proper foundation has been laid, and I'm following right along with the federal rules of evidence, and so I do see the proper foundation was laid. Over defense's objection, I will allow Exhibit number 4 to be admitted into evidence.
Rowley, what was the purpose of this letter?
We had not received compliance on this property on Valencia, 518 Valencia, and our second process happens 30 days after the first. So this second notice was sent to Ms. Carlton advising her and reminding her of the violations and giving her more time to comply.
Did you receive a response to this letter?
I received response. Ms. Carlton wrote me letters, and one was sent to my office and one was hand-delivered to our office.
I'd like to proceed with Exhibit 5, marked as Exhibit 5. Ms. Rowley, do you recognize this letter?
Yes, I do. It's the third and final process before court proceedings are filed.
And what is the date of the letter?
This is October 8th, 2020.
And did you write this letter?
Yes, I did.
Is this a letter you typically write as a building compliance investigator?
Yes, this is the third and final process before court. We file criminal charges.
And is this a record that you keep in your files?
Yes, it is.
And is it a regular practice to write these letters?
Yes, it is. It's the third process.
Thank you. Your Honor, I offer Exhibit 5 into evidence.
Hence,
Signed, and we haven't any knowledge or any proof that this was actually mailed. That's an improper foundation.
okay, Ms. Sanchez?
Mailing's not a requirement of a building, a business record.
Okay, Mr. Tapia, your objection is noted. I think you will have, an opportunity to cross-examine Ms. Rowley and ask her maybe some of those questions that you have, but I'm, denying your objection, or overruling your objection, I'm sorry, and I'll allow exhibit number 5 to be admitted into evidence. The foundation has been laid. Thank you.
Rowley, what was the purpose of the October 8th, 2020 letter?
This was the pre-criminal summons notice, once again allowing her time to comply and to come into compliance for the violations at the property at 518 Valencia Drive Southeast.
So at this time, you had not yet received a building permit for the property, correct?
No, we had not.
Okay. And again, how did you determine who to send this to?
The record of ownership of property was pulled off the Bernalillo County State of New Mexico website.
And did you receive a response from Ms. Carlton to this letter?
More phone calls, and by this time, her Mr. Tapia had contacted me.
Okay. Thank you. Your Honor, I'd like to offer those letters.
Okay, and so this is exhibit number 5, a pre-criminal summons notice. Defense, this is exhibit number 3. Okay, where is number 5? Is it, okay, so, but number 5 hasn't been admitted yet, so let's hold off on that. I have 3, you have 3 and 4 there. So, you're moving to admit exhibit number 5?
Yes, Your Honor.
I'm sorry, hold on, hold on. I'm sorry, I did admit number 5 into evidence. I apologize. Okay. And Mr. Tapia, you have copies of these exhibits? Okay. I'm just gonna hold on to all the exhibits here. Was there an exhibit number 2, Ms. Sanchez? Okay, so we're going from 1, 3, 4, and 5. I know those are how they're numbered in your, is there going to be an exhibit number 2?
Oh, I can renumber them, Your Honor.
I think for the record, I think they should be. Why don't we, do that? And I know that that's gonna throw off your numbering in your exhibit list, but I think to have a proper record, we shouldn't have any gaps in the, so those will be exhibits 2, 3, and 4, right?
Yes, Your Honor.
So it's not exhibit 5, it's number 4. Okay, thank you.
Okay, I'd like to talk a little bit more about the violations themselves. I would like to mark, so let's see, we just did 2, 3, and 4, correct? So the next exhibit will be 5. I'd like to mark plaintiff's exhibit 5, which is marked as exhibit 7-1.
Okay, are you, Ms. Sanchez, are you skipping over number 6 as listed in your exhibit list? Or is that, just so I'm keeping...
Yes, I am.
So you're not, you're skipping over 6,
Yes, Your Honor.
and you're renumbering number 7 that's listed there as number 5.
7-1. There
Okay.
are several photographs
Yeah,
marked
and,
as 7.
okay. So it'd be 5-1.
5-1, sounds good. So I've shown that exhibit to opposing counsel. May I approach the witness?
Yes, go right ahead.
Keep knocking that little foam rubber piece off, I apologize.
Okay, no problem.
Raleigh, I handed you what is marked as plaintiff's exhibit 5-1. Do you recognize this exhibit?
Yes, this is a photograph I took of the property located at 518 Valencia Drive, Southeast.
And when did you take this photograph?
I took this photograph on 8/18/2020.
Is it a fair and accurate representation of the property located at 518 Valencia Drive, Southeast?
Yes, it is.
And is it a fair and accurate representation of what you observed on your inspection on
Yes.
August 18th, 2020?
Yes, it is.
Your Honor, I'd like to offer this exhibit into evidence.
Okay, defense? Okay, and exhibit number 5, I guess, are you calling this 5.1?
5-1, yes.
Okay.
Thank you for the clarification.
Exhibit 5.1 will be admitted into evidence.
Thank you. Ms. Raleigh, will you please describe the photograph?
This is a photograph of the property at 518 Valencia Drive, Southeast. When I take these pictures before entering onto the property from the public right away.
And do you observe anything that looks unsafe?
There was a lot of construction debris in the front of this property.
Do you observe anything that would give you reasonable cause to think that the building might be unsafe?
There was a lot of debris showing some type of work was going on the property. So at that point, I was not sure if permits were needed or not. So that's my job, is to figure out if there's violations or not.
So, Your Honor, may I approach and submit this exhibit?
Hey, please show to Mr., I have a copy of your exhibits here. Okay, Mr. Toppy, you have a copy of that as well? It's exhibit 7-1 in your documents provided, but it's 5.1. Okay, and I have that in front of me, but you, that's been admitted into evidence, and it's actually better than what I have in front of me, so I'm gonna take a look at this while we're, okay, thank you.
I'd like to proceed with plaintiff's exhibit 5-2, which is marked as, it's marked as 5-2. It is exhibit 7-2 in plaintiff's list. Mr. Tapia, do you have that? Defense counsel has a copy of it. And may I approach the witness?
Yes, please. Okay, hold on. Sir, can we help you? Okay, have a seat in the hallway, please. If you're a witness, you have to wait to be called, okay? Oh, okay. Okay, have a seat. Thank you. Please, well, should they be advised not to talk to each other? I mean, the rule was invoked. Or were you also asking that witnesses not discuss the case with each other, Ms. Sanchez?
That would be helpful.
Okay, Mr. Tapia, can you please advise them not to, discuss the case with each other? It's an order of the court. Okay, thank you. Okay, Ms. Sanchez, go ahead and continue.
I believe I just handed you what's marked as Exhibit 5-2. Do you recognize this photograph?
Yes, I took this photograph on the 18th,
August 18th?
August 18th, 2020.
And is this a fair and accurate representation of the property located at 518 Valencia Drive Southeast?
Yes, it is.
Is this a fair and accurate representation of what you observed on your inspection on August 18th, 2020?
Yes, it is.
Your Honor, I offer this Exhibit 5-2 into evidence.
Vince? Okay. Exhibit 5-2 will be admitted into evidence. Thank you.
Ms. Rowley, will you please describe what you see in this photograph?
There was metal roofing that had been taken off some portion of the building. There is insulation wrapping, an empty kitchen sink box in the back, and numerous other building materials laying in this pile. Wood, blocks, and a whole hodgepodge of different types of building materials.
Is there a violation that you observe in this photograph?
The roofing material, it came off the property somewhere. I did look up and saw new TPO on the rim, white TPO. So I did ask Ms. Carlton if a new roof had been put on the property, and she said yes, a roof had been put on the property. Also in this picture, you can see new vinyl windows had been installed on the property as well. And she told me she did have new windows installed on the property after she purchased it.
And does a new roof require a building permit?
Yes, under administrative code, it requires, all re-roofs require building permits.
Does a repair of a roof require a building permit?
A repair over $1,000 requires a building permit.
And do new windows require a building permit?
Yes, they do. They're considered altering a building.
Okay, hold on one second, please. What was the last question, Ms. Sanchez? I'm sorry.
If new windows require a building permit.
Okay. The answer was yes, correct?
Yes.
Okay, thank you.
Mentioned in this photograph, you observed a sink box. Is that correct?
Yes, it is.
And does a new sink require a building permit?
No, not, it does not.
Okay, thank you. Your Honor, may I approach and give you Exhibit 5-2 for the record?
Yes, please. Mr. Tapia, you have a copy of this as well? 5-2?
Window?
That's the construction materials.
Oh, marked as 7-3 now,
That's right,
5-3?
it's marked as 7-2, but it's,
5-2.
Exhibit 5-2, yes.
Did I mark that?
Those are yours, you can.
Okay,
thank you.
thank you, and I have that here.
Right, Your Honor, I would like to have marked Exhibit 5-3, marked as Plaintiff's Exhibit 7-3.
Objection to 4 and 5. 3, 4, I do object to 5.
Okay.
5-5.
Okay, so we're on 7-3 right now, right? Ms. Sanchez, is that the one that we're on? We're on Exhibit 7, that's marked 7-3 in your exhibit list, but
Yes.
it's 5-3, right?
Yes, Your Honor.
Okay,
May I approach the witness?
yes, please. And you're just doing one exhibit at a time, right? Yes. Okay, thank you.
Would you prefer I do more? Okay.
No, but, Mr. Tapia, if there's no objections to these exhibits, I don't know if you all want to confer, and if there's no, how many more of these photos do we have? Well, it's 7-3 or 5-3 and 5-4. And then there's,
I think I'm just gonna enter in one more of the photos.
okay, and so I'll leave that up to you, but if you wanted to stipulate
Last
to
one.
to admitting them to evidence, I would be open to that as well.
I have no objection to that.
Okay, and Exhibit 5-3 will be admitted into evidence with no objection from defense.
Ms. Rowley, do you recognize this exhibit?
Yes, it is the backside of the property at 518 Valencia Drive, Southeast.
And did you take this picture?
Yes, I did.
When did you take it?
This was done on 8/18 of 2020.
Is this a fair and accurate representation of the property located at 518
Yes,
Valencia Drive Southeast?
yes, it is.
And is this a fair and accurate representation of what you observed on your inspection?
Yes, it is.
And can you describe what you see in the photograph?
This was showing the new vinyl windows that were installed on the property at 518 Valencia Drive, Southeast.
And is this a violation of the Uniform Administrative Code?
Yes, it is.
What is the violation?
The violation is the structure had been altered, which new windows required a permit.
Thank you. Runner, may I approach?
Yes, please. Okay, thank you.
Thank you, Ms. Rowley. Honor, I would like to request to mark the next exhibit as Exhibit 6, which is marked as Plaintiff's Exhibit 8. There's a letter from Ms. Carlton to Ms. Rowley. This will be Exhibit 6.
So we only did 5-5, right?
We only went to 5-3, which is 7-3. So, is the city gonna be moving to admit, well, I mean, we don't need to know right now, but I'm gonna clip the ones that weren't admitted yet, just so I have those, on this. Okay, thank you.
May I approach the witness?
Yes.
Rowley, I've just handed you what has been marked as Exhibit 6. Do you recognize this exhibit?
Yes,
What do you recognize it to be?
this is a letter I received from Miss Eleanor Jane Carlton.
What is the date on the letter?
The date is August 28, 2020.
And how do you know this is from Ms. Carlton?
It was delivered to our front staff, and they put it under my door. I was not in the office at that time.
Do you have the original letter with you today?
I do.
Okay, thank you. When was the first time you saw this letter?
I received it on 8/31/20. It was, when I came into the office that morning, I found it on the floor of my office.
Your Honor, we move to offer Exhibit marked 6 into the record.
Okay, defense?
I have
three.
2 pages.
Well, it's 4 pages,
exhibit.
right?
I have 2 pages. There's a separate letter, which is another,
Oh, wait a minute.
would be a separate
Oh,
exhibit.
I see. So this one doesn't have, oh, it looks like okay, Miss Sanchez, Mr. Tapia is stating that it's not, there's no signature on this. So are you objecting, Mr. Tapia?
I object, and it also has some writing put on after, on the top right-hand corner.
Okay, and so what's the objection?
The objection is that it is, not, it's hearsay to this witness. Also objectionable since it's not signed, and, it has writing on it. That's it.
Okay,
It was placed there after in pursuit of litigation.
okay, Ms. Sanchez?
This is an opposing party statement made by Ms. Carlton. It was a letter provided in response to Ms. Rowley's notice of violation. The first one dated August 19th, 2020, which has been admitted as Exhibit 3. Additionally, there is admissibility of a duplicate, and we do have the original with us today.
Okay, can you say your first statement again? There was another letter on what date? I'm sorry?
Exhibit 3 that's been admitted was Ms. Rowley's first notice to Ms. Carlton, dated August 19th, 2020. The exhibit I'm offering as Exhibit 6, marked at the top as Exhibit 8, is a response from Ms. Carlton. And so the authentication of this letter is based in the fact that it responds to the notice of violation.
Plaintiff's Exhibit number 3 is the second red tag notice?
It is the red tag first notice.
Oh, so, okay, so that must be that's Exhibit 2.
2, excuse me.
Okay, so, okay, I was looking at the wrong one. Okay, and okay, so I think defense is arguing that this letter hasn't been properly authenticated, that it did come from Ms. Carlton. What's your response to that, other than that it's in response to Exhibit number 2, the letter that Ms. Rowley sent to Ms. Carlton? I mean, I think it's a valid objection that, how do we know this is from Ms. Carlton?
Primarily from the first letter, the first sentence of the letter, and
okay, so why don't you continue to ask Ms. Rowley some questions for right now, I'm sustaining the objection until proper foundation has been laid. I think I need to hear more for a foundation.
Ms. Rowley, could you please without reading any of the letter, could you please describe what this letter was in reference to?
It was in reference to the response from the first notice I sent Ms. Carlton for the property at 518 Valencia Street Southeast, explaining what had been done to the property.
You mentioned you also spoke to Ms. Carlton after the notices of violation, correct?
Correct.
And in one of your phone calls, did Ms. Carlton ever state that she was going to send you a letter?
The response as to there's an objection.
This is again an opposing party statement.
Okay, Mr. Tapia, anything else? Okay, I'm overruling the objection. Go ahead.
You can answer the question.
Can you repeat that?
Yes. In one of your phone calls with Ms. Carlton, after sending the August 19th, 2020 letter, did Ms. Carlton state that she would send you a letter?
Yes, she did.
And did you receive this letter shortly thereafter?
Yes, I did.
Your Honor, I would move to admit exhibit marked plaintiff's exhibit 6 into evidence.
Okay, defense? I'm
There's
sorry?
not gonna be nothing further.
Okay, so, you don't have any other objection?
No.
Okay, and, sorry, the city's exhibit, what exhibit are you offering this as? I'm sorry.
Exhibit 6,
Exhibit 6 will be admitted into evidence.
thank you. You have the letter, correct?
Yes, I do.
Okay. Would you please read the first sentence of this letter?
After I read the red tag on my property at 518 Valencia Southeast last Thursday, I called you and commented, "This make me look like public enemy number one." I wondered who would have...
That's good, thank
Okay.
you. And so it's your understanding that this letter is from Ms. Carlton, correct?
Yes, it is.
And on the second page, starting at the first full paragraph, will you read the first sentence starting with, "As I told you"?
As I told you last week, the windows, roof, and plumbing were installed before the 2018 building code was written.
Thank you. So is it your understanding that Ms. Carlton is admitting to doing work without a permit for windows, roof, and plumbing?
Yes, it is.
That's all I have on this letter. May I please approach the bench?
Yes, please. Thank you.
Your Honor, I would like to mark,
Okay, and this is, this one was only 2 pages long.
yes,
Okay.
6, right?
that's 6.
Yeah.
And so I would like to request to mark Exhibit 7, which would be the subsequent letter, marked as Plaintiff's Exhibit 9 in the list, a letter dated September 5th, 2020.
Seven, let's change it up.
Your Honor, may I approach the witness?
Yes.
Ms. Rowley, do you recognize this exhibit?
Yes, I do.
And when was the first time you saw it?
I received this in the mail, and I do have the original envelope with me that was sent with the letter.
And who was this letter from?
This was from Miss Jane Carlton.
Is her signature on this letter?
Eleanor Jane Carlton, J.D. Yes.
And do you recognize Ms. Carlton's signature?
No, I had never seen it before.
Okay. Was this, do you know if this letter was provided in response to one of your notices?
I believe it was in response to the first notice because the second notice had not been sent out yet.
Okay, so this would have been a second response.
Correct.
Okay. And, Your Honor, I would like to offer this exhibit into evidence.
Okay, defense? Okay. The city's exhibit number 7 will be admitted into evidence. Okay. Okay. let's hear your objection, Mr. Tapia.
Not placed there at the time that the letter was received by Ms.
And what,
Crowley, and I believe that it causes some prejudice to my client so far as highlighting and telling court to look at certain aspects.
okay, Ms. Sanchez?
Your Honor, this letter was highlighted by Ms. Rowley, for her own notes and records. The city does have the original letter. I would have to ask Ms. Rowley if the original is also highlighted, but we may be able to offer the original as well if there's any concern about prejudice.
Okay, go ahead and I'm gonna reserve ruling until I hear anything more, but, do you have additional questions to ask Ms. Rowley then? Yes. Go ahead.
Ms. Rowley, we noticed that this letter is highlighted. Did you highlight this letter?
This was highlighted, after I received, by myself, after I received the letter. When I do get correspondence like this, I need to go through and, highlight what violations are, being, looked at for the property. So this was done for my records.
Records. Do you have the original with you here today?
I do.
Is the original also highlighted?
It is.
And did you highlight this for the purpose of the court?
No, I did not.
Your Honor, we would offer this exhibit into evidence, showing that the purpose of the highlighting was not to provide any sort of direction to the court. It was for Ms. Rowley's own notes. And if it is admitted, we will go through sections. Some are highlighted and some are not.
Okay. Anything else from defense?
I stand by my objections, Your Honor.
Okay, the objection, to this being admitted in evidence is overruled. Defense will have the opportunity to cross-examine Ms. Rowley on any of this. Thank you. And it'll be admitted, into evidence. This is exhibit number 7, right?
Yes.
Okay.
Ms. Rowley, what is the date of this letter again?
September 5th, 2020.
And you stated this letter is from Ms. Carlton, correct?
Correct, yes it is.
As noted on the second page.
Yes.
Would you please read the first sentence?
I want to put everything I have to say in writing so I have an accurate record of what I said. First, I need to click.
Oh, that's good, thank
Okay.
you. On the second paragraph, would you read the second sentence that starts with the buildings at 518 Valencia?
The buildings at 518 Valencia Southeast were built around 1952.
Please continue with the next sentence.
Several additions have been added over the years, but everything that is there was there before I bought it on July 20th, 2017.
Will you please read, starting with the third paragraph, the first sentence that says, the first item I dealt with?
The first item I dealt with after I purchased the property was plumbing.
Does plumbing require a permit under the Uniform Administrative Code?
Yes.
And so is it your understanding here that Ms. Carlton admitted to doing plumbing work without a permit?
Yes.
Will you please move down in that paragraph to the fourth sentence? It starts with, I asked around and located.
I asked around and located a company who replaced everything in both buildings with PEX, including both water heaters.
Do you know what PEX is?
PEX is a product. It's used for plumbing. It's a plastic product.
Okay. Is it your understanding in this sentence that Ms. Carlton admitted to replacing the water heaters?
Yes.
And does replacing water heaters require a permit under the Uniform Administrative Code?
Yes, it does.
Thank you. Let's move down a little further in the letter. In the fifth paragraph that has bold stating roofing, you could move down to the last sentence of that paragraph, starting with, I quickly had the roof replaced.
Where you're looking at?
Yes, so let's see.
Oh, I see. I see where it is.
We are on the
The second paragraph in the bottom of the first page.
I guess it would be the sixth paragraph, starting with your letter complains about roofing,
Okay.
the last sentence.
I
Could you please read that?
I quickly had the roof replaced with the best possible material early in 2017.
That you're understanding that Ms. Carlton is admitting to replacing the roof without a building permit in this sentence?
Yes.
And you already mentioned before that replacing a roof requires a building permit, correct?
Under the Administrative Code 2018, yes, it does.
Thank you. Can you please read the next sentence, which is the last of that page?
Likewise, the complaint about windows does not apply because they were all installed as quickly as possible after I closed on the property so I could have the building stuccoed.
And what is your understanding of this sentence?
That the windows were all replaced.
And does that require a building permit under the Uniform Administrative Code?
Yes, it does. It falls under the Administrative Code, under 109, under altering the building or structure.
Thank you. On the next page, on the fourth paragraph, would you please read that paragraph starting with the first thing I wanted to do?
First thing I want to do is get a hold of my gas contractor and arrange to have those heaters, stove, and dryer installed and have him check the new water heater. Those things are required under the 2018 code. Of course, I expect to pay for the permit.
So what's your understanding of this paragraph?
That Ms. Carlton intended on obtaining a permit for the work described in this paragraph.
And did Ms. Carlton, in fact, obtain a permit for the new water heater?
No, she did not.
Thank you. I don't have any further questions about this exhibit. So since the first notice of violation was issued August 19th, 2020, has anyone applied for a permit at the property located at 518 Valencia Drive Southeast?
Application was submitted and it only sits in draft form at this point. No permit has ever been issued.
So the property continues to be in violation, correct?
Yes, it does.
I'd like to move to defendant's exhibit of the 2018 Uniform Administrative Code to section 108.2, which is marked as Carlton 30. May I approach the witness?
Yes. Please show Mr.
Yes.
Mr. Tapia first what you have. This is the, you need a moment, Mr. Tapia?
You may have it. No, you let me have a copy.
I don't have a...
It was in the binder that you provided to the court.
Yeah, I thought my binder was here. I brought it.
That's not what you have right in front of you?
Oh, there it is right here. Sorry.
It's okay, it's such a big thing, there's a lot on that table as well. Okay.
I apologize.
Okay, so do you have that in front of you, Mr.
I was
Tapia?
panicking. Yeah, page 30 what?
30.
I better have it, right? Yes, ma'am. Okay. What are you gonna mark it? 8?
No, it's not an exhibit, this is the law governing the case, right?
Yes, Your Honor.
Okay, and, I just wanted Ms. Sanchez to show you what section she was referring to, so you would know.
All right.
Okay, go ahead, Ms.
Approach
Sanchez.
the witness?
Yes. Ooh, excuse
Ms.
me.
Rowley, do you recognize this as the Uniform Administrative Code?
Yes.
And will you please read section 108.2, the last sentence.
A violation of this code shall be considered a separate offense for each and every day or portion thereafter the violation is committed, continued, or permitted.
And so what does that mean for building and safety?
It means the violation still exists as long as there's no permit on it. It continues to be a violation each and every day prior to being permitted.
So that means that the property continues to be in violation today, correct?
Yes, it does.
And that each day it continues to be in violation is a new violation.
Is a new
correct?
violation, correct.
Okay, thank you. And I don't have any further questions for Ms. Rowley.
Okay,
Oh, Your
and,
Honor, I don't believe I offered this.
which exhibit is that?
7?
Okay, let me see which is the last exhibit I have. Yes, that's right, I only have exhibit 6. Okay, thank you.
Ms. Rowley.
You're welcome.
Okay, and Mr. Tapia?
Yeah, there you go.
Morning. It is.
Carlton in this matter, and we took your deposition in this matter previously.
Mr. Tapia, you know what, you're gonna need to speak up. You know what, I would suggest you pick up the whole microphone and put it on the ledge there, there's a ledge on top.
It's not coming up. No,
Oh, it
don't
won't
get
come up. Okay, so try to, just,
I'll try, we'll get it together.
okay,
I'll
yeah,
be
just so
trying.
I can hear you
And
better,
just
'cause
let me
it's,
know,
okay,
because
I can hear you better
it's
right
kind
now.
of uncomfortable, I can't, to try and hunch over and,
Or you can,
think.
you can stay there, or you can go to your, back where you were, whatever is more comfortable for you, Mr. Tapia. But, Alex, do you know if you can?
down on this one.
It's okay, but if you prefer being at the podium, we can take a break for a moment and
And stretch it out?
yes, let's take a break. Let's pause for a moment. Can you go down there, Alex, and help him? See this microphone, this long cord? There's a ledge on top. If you can put it on the ledge, it'll be closer to his face so that we can hear better.
I think if I tip it, I may be able to pull it. Yeah, that's about it. A little more. Yeah.
Well, let's move the podium a little bit. Maybe that will help. Okay, there, and then if you can angle it, then you don't
Is
have
that
to lean
good right
down.
there?
That is much better. Thank you, Alex. Okay, good.
Oh, you recall having your deposition taken in this matter?
Excuse me?
Sorry. Did you recall having your deposition taken in this matter?
Yes, I did.
Okay. Now, Ms. Rowley, if looking at what your previous statements were made, you were on the job approximately 10 days before you were cited, Ms. Carlton. I call her Eleanor, but...
No, I started August 3rd of 2019. I had been there over a year.
Okay. You'd come from where?
City of San Diego as a building inspector.
All right. And you were hired, what was your position here with the city of Albuquerque?
A building complaints investigator.
All right. Now, you received the call or a computer printout telling you about the anonymous call?
We are given a printout of the 311 calls, and we go through to verify if permits, if it's a valid complaint or not.
Now, when you issued the red tag, there was some confusion. Is the one that was submitted to evidence the first one you issued?
I would have to see which is the exhibit.
Yes.
No, that was not the first. That is a notice, not a red tag. A red tag was what I issued on the 18th of August.
And left
Mr.
on the
Tapia, I'm gonna leave these exhibits here. If you want to use them, just please make sure that, they are returned back to the court. I think it's 1 through 7.
You were, oh no, never mind. She didn't admit it, or wasn't admitted.
Which one?
No, it wasn't.
The red tag, she withdrew it.
Okay. You can keep those there for your use, but let's make sure we get those back.
Ellie, when you discussed this matter with Ms. Carlton, she told you that construction had been done prior to 2018, it didn't apply.
Rephrase your question, can you?
When Ms. Carlton stated to you that the 2018 code did not apply in this matter, that the work had been done prior to the enactment of the code. Do you know when the 2018 code came into effect?
The effective date is on the front of the administrative code.
November 2018, isn't it?
I don't know. I don't have a copy in front of me.
So, you don't know? Oh, here we go.
Show it to me.
You did it after I told you that it was.
Yes. November 1st, 2018.
So, she was cited in 2019, correct?
Correct.
You said you were hired in 2019?
I was.
Huh?
Yes.
August of 2019?
August 3rd, 2019. Correct.
Okay, and when did you initiate the first red tag notice?
August 19th of 2019.
Okay, so when I asked
2020, excuse me.
Okay, that's, oops. I had a different point that doesn't fly. Now, when you inspected the premises and went onto the property, did you take the pictures before or after you had spoken to these individuals?
Those were taken after I spoke to them, except for the one from the public right away.
Which was that one?
That is the one of the property that shows, it's the first exhibit that was,
Exhibit 5-1?
yes, correct.
Exhibit 5-1. Now, have there been any of
No.
No.
They just did not allow me in access to the inside. They told me I would have to make arrangements with Ms. Carlton.
Ms. Carlton met you at the property. Who were you with?
I was with my supervisor at the time, Ms. Lois Blocker.
And she's retired now?
She has since retired.
Okay, and you presently have her position?
I presently hold her old position, correct.
Congratulations.
Thank you.
Now, in reading the 2018 code, and for judicial notice, Your Honor, you can pull it up on your computer.
I have the 2018 code in the binder. Is that the one you're talking about?
Yes.
Okay.
However, I would suggest that the court look at it on the computer, because then you can type in the word that you're looking for, like for instance, windows or roof, and it'll give you how many times the word is stated.
Okay, I'll just let you ask her the questions, and then we'll see where you're going with this.
All right. Now, in your citation to Ms. Rowley, you state that windows had to be permitted.
Carlton?
To Ms. Carlton, what did I say?
Ms. Raleigh.
No, I apologize. Yes, and can you tell me in the code where that is stated?
It's, the code is under the administrative code. We use a general building code for all violations, which talks about a property being changed or altered. It falls under the 109, the Uniform Administrative Code.
That is not part of, this is the Uniform Administrative Code?
Yes, it is.
This is the one we're talking about?
Yes, it is.
2018, you said that since she was cited in 2020, 2018 code applied.
We had not adopted another code. We were still enforcing under that administrative code.
Okay, on page 1, it states what effective codes were coming forth, Exhibit A, as adopted by the Construction Industry Division, number 18, states that the, existing building code is still in effect. Isn't that true?
The Uniform Administrative Code is adopted by the city of Albuquerque. And then if we need more restrictive, we then go to the building code.
Okay. Now, this code has nothing about windows being required to be permitted. Can you direct me to where you find that, as a permitted requirement on any of the other codes that you're talking about that are included?
Under the 2018 Uniform Administrative Code, and that is because windows are considered an alteration on a building, which require a building permit.
Section that states that?
109.1. It's on the notice, the legal notices that were sent to Ms. Carlton. Under 109, UAC 109. It was cited on the notices Ms. Carlton was given.
And it's in Carlton's, 31, your exhibit. Are you, well, okay, I'm not gonna assist. I think, Mr. Tapia, I'll let you do your.
Well, it'll save us time if we all work together.
Okay, well, if you're looking for section 109, permits, it's, Carlton 31.
Yes. Building permit has been obtained. Now, how do you reconcile that with the Uniform Commercial Code that states there's nothing about windows?
This is not a commercial building, it's a residential.
Right, it's a residential building. I'm sorry if I said correct. Now, how do you reconcile that if there's nothing in the Uniform
Section,
Code 2018?
Let's hear what the objection is first, Ms. Sanchez.
Mr. Tapia is assuming facts not in the record.
Okay, Mr. Tapia, let me hear your response.
Facts are, she stated that the Uniform Administrative Code is what applies. Now, I don't know what other facts there is. She says it applies. I want her to tell me where it states that windows are required to be permitted.
Okay.
A general statement that she states, I still don't reconcile it. It doesn't reconcile with me.
Okay, and Ms. Sanchez, I think your objection was, again?
He's assuming facts not in the record regarding other codes that we have not yet examined.
Okay, and your response,
I asked if there was any other codes. I don't know. I'm not asserting there's any facts. I just asked if there's any other codes, please bring them in and explain to me how they apply other than the Uniform Administrative Code.
okay, and the objection will be sustained, Mr. Tapia. I agree with the city that these are facts, not in evidence. The code that is relevant and the code that this case is charged under, that these charges are under, is the 2018, and that's what's been, yes, Uniform Administrative Code, and that's on the charging document as well of the criminal complaint that was filed on October 23rd, 2020, cites Section 109.1 of the 2018 City of Albuquerque Uniform Administrative Code. So, I'm sustaining the objection. Move on to your next question, please.
So, can you tell me where in the 2018 Uniform Administrative Code there's any section regarding requirement of windows? There's not one, right?
Under alteration of a building under 109.1. An interpretation.
So within the code, there's no requirements of windows being permitted, is there? Other than 109.1. Now, how about the plumbing? If are you telling me that the person can't change out his toilet, change out his water heater, or change out the new, like, sink goes out and I have to put a new faucet, I have to get a permit?
Have to get one for a water heater. It's not required for a toilet, and it's not required for a faucet.
So you cited
A water heater involves gas.
Now, you stated that there had been no permits on that property, right?
I looked back to, our records go back to 1983, and there were no permits ever pulled on that property.
Carlton, that she bought the property in 2017.
Says she bought it, I believe, in July of 2017.
Yeah.
I do not. Public records show when she purchased the property.
So when she tells you that she didn't put any new rooms on there, are you still going to cite her for putting new rooms on that?
Objection?
To the objection?
This is not a listed violation. I'm not sure why we're discussing new rooms.
Is your objection, to relevance?
My objection is to relevance.
Okay. Mr. Tapia, the relevance of that question you just asked?
Maybe I'm confused, I apologize. So there's no
Okay.
violation for adding rooms?
Okay, hold on. But there's an objection as to relevance. What's the relevance of this question, Mr. Tapia? I need your response.
If you look at the red tag, the initial red tag on the property states that there was violations of this matter. So I just want to know, we'll take them off. If they're not on there, I apologize, we move on.
There wasn't a...
Red tag wasn't admitted.
There wasn't a red tag notice admitted.
Okay.
Correct, Ms. Sanchez?
Correct. However, the first red tag notice letter was admitted and identifies the violations.
So there's no citations for adding rooms. Is that what you're saying?
Not part of this hearing. It's not in my violation.
Yes or no, please? It's not, or it isn't in your violation?
Can you repeat your question?
Yes. There was initial mix-up or maybe confusion regarding what the citation was for. Mr. Carlton addressed it and stated when she bought it and what was there when she bought it. Have you included any violations relating to expansion of the properties? Water heater was hooked up when you saw it? Did you take a photograph of it?
Yes, I did.
Now, putting in anything else that you found as violations? Besides the roof.
What is your question?
Anything else that you cited her as violating the specific part of the code, 109?
The roof.
Objection.
Okay, hold on.
Asked and answered.
Okay, and specifically, Ms. Sanchez?
It's already been established by Ms. Rowley that she's identified the violations.
Okay. Mr. Tapia?
I'll look at Exhibit 2.
Okay, and I would sustain the objection, Mr. Tapia. That question was asked in direct examination. And so I guess if you have a follow-up question regarding that, you can ask that.
And now, I just wanted to make sure that we weren't beyond the scope of what she was being noticed about. Now, in looking at the dispute about the windows, now the roof, you stated it needed a permit. And do you believe that Ms. Carlton did the work and put in the roof?
She did not. She told me she had somebody install the roof.
Contractor, isn't it their duty to get a license permit?
It falls on the property owner to make sure that whoever she hires follows through with the permits.
Regarding the plastering or stuccoing on the building,
Objection, relevant.
Okay? And
you're not disputing that that is a violation?
hold on, Mr. Tapia. Don't answer the question yet, Ms. Rowley. There's an objection as to the last question. The question was regarding stucco. Ms. Sanchez, you had an objection to that?
Yes, relevance, this isn't a listed violation.
Okay, and the objection sustained. Sure. Sally, do you need water? I think I have some water. Please. Okay, let's, can you call Erica in the back and have her bring 1, 2, 3, 4? I have waters for my car. I have one here, but I don't know where that came from. We had students that were doing moot court. It's been sitting there ever since, and I'm like, I should probably get a new one. I don't know. It looks fine, but you never know. Hold on, Mr. Tapia. We're gonna take a quick break. We're gonna get waters for everybody. Okay. We continue while we're waiting for that. My secretary will be bringing those out. Go ahead, Mr. Tapia. Did you have another question?
Yeah, in Exhibit 501, you stated that it was unsafe.
I see it.
It was unsafe to the public, you stated.
Well, there's construction materials in the front of the property.
It's in the enclosed yard, right?
Yes.
That's the extent of the hazard to the public?
No, there's construction materials leading us to believe, since it was reported that there were non-permitted building going on the property. So if it's something that requires a permit and it has not been permitted, inspected, or approved, we consider an unsafe situation until the proper permits and inspections have taken place.
Let's hold for one moment, let me hand over some. I'll give one to you, Mr., and we can, and my clerk. Yeah, no, not that one, Mr., no, this one's been sitting here forever, so, this one that's cold, yes, take that one. Alex, can you hand those over there, please? You can just, okay, you can just hand them to Mr. Thomas, hand those out. Thank you, Erica.
Thank you, Your Honor.
Oh, sure, no problem, we can take a little. I don't know if they use that. Okay. Okay, and you put these back? Okay, let me just make sure they're all here.
Ms. Rowley, so, other than the statements made by Ms. Carlton, you don't know when that roof was installed, do you?
I do not.
Okay, you do not know when any of the other work was done?
I do not.
All you know is what in other statements that Ms. Carlton made was it was done in 2017, early 18.
Never heard letters stated.
Yes. Did you have any ground to not believe that?
I did witness new work inside when she gave, the interior inspection. There was new work.
What was that?
There were, new shower valves installed. There was also a new shower surround installed, which still had the stickers on it.
An opportunity to look at the existing building code? That code that we just mentioned?
They're only citing the violations under the 2018 Administrative Code.
Looking at that, have you had an opportunity to look at the existing building code?
Why would I do that?
It's cited on page 2 of the building code.
Right. That falls under the more restrictive. If we don't have, a code to list under the administrative code and we need a more restrictive code, then we go into the existing code or the IRC code, the residential code. I did not. When we need a more restrictive code.
Restrictive code, okay. Now, let's look at,
Okay, your objection, Ms. Sanchez?
I don't know what the relevance is of this.
Okay, Mr.
Additional
Tapia,
code.
there's an objection as to relevance.
relevance is, Your Honor, that the International Residential Code in 2015, learned treatise that has adopted, as she stated, has some sections that tell us about the permits required.
Okay, but how is that relevant, Mr. Tapia? The objection is to relevance of that code being, essentially introduced and you asking questions, Ms. Rowley, questions about it.
It's relevant because this is a code that is applicable and it is followed by, Ms. Carlton.
Okay, and you're saying it's applicable. How is it applicable?
She stated that it's used.
Okay, I heard Ms. Rowley state that it's used when a more restrictive code is needed. And so I'd like you to explain to the court, how is that, code relevant in this case today with the charges against Ms. Carlton?
Is that this code applies.
Okay,
And it has to be, recognized and it has to be delved into. It's our defense.
okay, Ms. Sanchez?
There has not been any facts established as to why this code would apply. Ms. Carlton was cited under the 2018 Uniform Administrative Code, and Ms. Rowley has not cited the International Residential Code at any time.
Okay. Mr. Tapia, any further argument?
These are part of the code. So we believe they're part of the code.
Page 2,
No, page 1, first page. The second page, the first page is a cover page.
And what section are you referring to, Mr. Tapia?
Chapters. So this raises reasonable doubt as to what code should apply, what code doesn't apply, and whether or not there's a reasonable person can understand what violations are, what they're supposed to follow.
Okay, Ms. Sanchez, anything else from you?
No, just that the violations were cited under the administrative code, and there wasn't any ambiguity in citing the violations.
And Mr. Tapia, I'm going to sustain the objection and not allow you to go down this line of questioning involving the International Residential Code. Let me see, that's what it's called, right? The International Residential Code?
That's 2015.
Okay, and what I'm relying on, Mr. Tapia, is the actual criminal complaint that was filed in this case, and the statute that's cited, or the ordinance that's, the law of this case that Ms. Carlton was charged under, and it says on the complaint, section 109.1 of the 2018 City of Albuquerque Uniform Administrative Code, and it says no building or structure, and it, goes on and just states exactly what that violation is, as in 109.1, how that reads. And so I'm sustaining the objection that the International Residential Code, raising that issue at this time is not relevant to this case, because Ms. Carlton has not been charged under that. And essentially the prosecutors in the case, the city has the right to charge under codes that they believe are applicable, and I understand what your argument is, that you're arguing that this doesn't apply, but that's what she's been charged under, and the city has to prove that she has violated the code that they've cited in the complaint as the statute she has violated. So I'm sustaining the objection. I won't allow this line of questioning regarding the International Residential Code. Sure.
3 of the International Code, R1051, is required. Any owner-authorized agent who intends to construct and enlarge shall obtain a required permit. At work, exemptions from permit. And it goes on. In listing in electrical, we charge it? No. With gas, there's portable heating, cooking, or clothes drying appliances. Placement of any minor part that does not alter approval of equipment or make such equipment unsafe. Portable fuel cell appliances that are not connected to a fixed piping system or are not interconnected to a power grid.
What's the offer of proof, Mr. Tapia?
My offer of proof is this is the code that we think is relevant and applicable to the case.
Okay.
Repairs, R105.2.2, repairs. Applications are noticed to the building official, not required for ordinary repairs to structures, replacement of lamps, or the connection of approved portable electrical equipment to approved permanently installed receptacles. Also, provision for emergency repairs. Clearing, and here's under plumbing, the clearing of stoppages or the repairing of leaks in pipes, valves, or fixtures, and the removal and reinstallation of water closets, provided such repairs do not involve any required replacement or rearrangement of valves, pipes, or fixtures.
Okay.
That's it. That's
Okay.
it, Your Honor.
Well, that hasn't been provided to the court as an exhibit. Regardless, though, Mr. Tapia, that I've already made a ruling, and I'm standing by my ruling that code is not relevant to this case because Ms. Carlton has not been charged under that, and a defendant doesn't get to choose what statute they're being charged under. The prosecuting agency are the ones who determine what statute the charge is being charged under, and that's what the city has done in this case. They decided that Ms. Eleanor is alleged to have violated Section 109.1 of the City of Albuquerque Uniform Administrative Code. So,
as a defendant, she has a reasonable grounds to understand what she's charged with.
okay, and so I believe that was done at an arraignment, right?
We state that the code is applicable as the code, not just that 109.1. So
Okay.
we would want to elaborate, and the question would be, is a reasonable person allowed to understand what she's charged with and how the codes apply to her? We could stick this to 1.019.1, but that doesn't tell you the exemptions. It doesn't tell you about the existing building codes. And so there's some reasonable grounds for reasonable minds to differ. That's what our defense is.
Okay, and
as far as, I didn't put it in because it's just a book. It learned a treatise that I was going to submit to the court, not as an exhibit.
Okay.
Unless the court wanted to see it.
well, again, the city has argued that International Residential Code is not applicable to this case, as Ms. Carlton has not been charged under that. She's been charged under the Uniform Administrative Code. Okay, and so I'm going to sustain the objection. Like I said, Mr. Tapia, a defendant does not get to decide what statute or what law applies when there has been an alleged violation. It's cited in the criminal complaint, the section that Ms. Carlton is alleged to have violated, and the city chose Section 109.1 of the 2018 City of Albuquerque Uniform Administrative Code. So that's the law that applies to this case. There's no argument to be made, Ms. Carlton. This is the charging document, the criminal complaint that cites the allegation as well as the code that the city believes you have violated. And so that's the law that applies. A defendant simply doesn't get to choose what statute they think that applies to their case. That's not how it works. When somebody is charged with a charge of any charge, whoever's prosecuting the case files a complaint with the allegations, cites the statute that they believe has been violated. That's what the city has done. The defendant does not get to choose what statute they believe. Here's what I found. What they believe has been violated or what the case falls under. The city has chosen to prosecute this case under Section 109 of 2018 City of Albuquerque Uniform Administrative Code. I've made my ruling on that issue. We're going to move forward.
Understanding the code that you
I can't.
I'm sorry. It's in listening and reading the code that is applied in the complaint. Did you have an opportunity to see that the complaint states that that the charge is a petty misdemeanor?
Whatever is cited in there. I don't understand your question, Mr. Tapia.
Oh, is this considered a petty misdemeanor?
It's considered a criminal complaint.
Okay, and what, the charge is it considered a petty misdemeanor, or a felony, or a misdemeanor?
I believe it's a misdemeanor.
Okay. Is it a petty misdemeanor?
I-
That's a legal argument. I have nothing further, Your Honor.
Okay, thank you. Okay, are those all the questions that defense has for cross-examination? Mr. Tapia, are those all the questions you have for cross-examination? Okay, so Ms. Sanchez, your redirect?
Carlton, when a property owner receives a notice of violation like you've provided in this case, citing section 109.1, and a property owner comes in for the building permit, how are they to know what the specific requirements are for each of the violations?
They're explained to them, and how it applies to their property. I tried to explain that to Ms. Carlton, but she didn't feel that it applied to her.
Are there additional technical standards within the Uniform Administrative Code that would explain what some of the technical requirements are?
Yes, there are.
And did you provide this information to Ms. Carlton?
Yes, I did. I told her she could get a copy of the 2018 Administrative Code, which she did.
Great, thank you. No further questions.
Okay, so, can Ms. Rowley step down then as a witness?
Yes,
Okay.
thank you.
And so, and does either side want to reserve Ms. Rowley for rebuttal? Okay, defense would like to reserve Ms. Rowley for rebuttal. So Ms. Rowley, you can remain. I guess Ms. Rowley is considered a witness, correct?
She's a witness and also considered to be like a law enforcement officer in this case.
Okay, so the rule was invoked, so, I guess the question is whether Ms. Rowley should be allowed to remain for the remainder of the trial.
I could suggest, Your Honor, she could be excused if we can call her up on the phone if we...
Well, let me hear from the city, because I want to hear their response and what your response is.
Ms. Rowley does represent the party, which is the City of Albuquerque Building and Safety Division. If there's any questions regarding those provisions or any technical standard in the building code, Ms. Rowley would be the expert to answer those questions.
Okay, so what's your response to her being why should she be allowed to remain?
Well, that's basic fairness, Your Honor.
Okay, I'm asking Ms. Sanchez, please.
Oh, I'm sorry.
And I'm asking that question
Yeah.
because the rule was invoked.
Yes.
And there are other witnesses that are going to be testifying, and in fairness, but I wanted to hear a response from the city.
I think, it would, to be fair, Ms. Rowley could be excused. However, I'd like to reserve the right for rebuttal if there are additional technical questions about the Uniform Administrative Code.
Okay, so why don't we reserve Ms. Rowley for rebuttal for both sides? Ms. Rowley, since you are a witness and the rule was invoked, I'm going to have you, I'm going to excuse you. And you can wait in the hallway, down the hall, or be somewhere nearby. You could even leave the courthouse as long as you can get back here within...
My office is within 6 minutes.
Okay, if you can get here within 10 minutes, that's fine.
Okay.
But I'll excuse you just in fairness since the rule was invoked.
Thank you, Your Honor.
Okay.
Thank you. When I needed.
So we would, if they want you to come back, we would give you time to get back. So if you can be within 10 minutes, that's great.
Thank you.
Thank you, Ms. Rowley. Have a good day. Okay. And does the city have any other witnesses to call?
No, Your Honor.
Okay. So is the city resting at this point?
Yes.
Okay. And defense, do you have a motion for directed verdict?
Yes, ma'am.
Okay, let me
I
hear
don't
from...
believe that the code, they have been able to not proven beyond a reasonable doubt. Oh, I'm sorry, I just gotta get over here. I'm sorry, Your Honor, but I don't believe that there has been a proof of every element of the crime alleged. There's a fact that she didn't have a permit, but our contention is that the citation for 109.1 has to be elaborated on and looked into as far as what the code states. Page 1 of the code states what parts apply. To be specific, I don't believe that there's been beyond a reasonable doubt any proof that there was anything done under her guise at her time that was not done by licensed contractors who we feel had the duty to permit. She didn't have the duty to permit, and we have some contractors that are here today to testify to that effect. Now, I don't know what they did or didn't get permits, but they'll be here for the court to know. I don't think that it's been sufficient evidence to prove that Ms. Carlton has violated 109.1 of the code.
Okay. Ms. Sanchez?
The city has demonstrated the elements of the crime, specifically identifying Ms. Carlton as the property owner. As such, she is the responsible party for anything that occurs on her property. Additionally, Ms. Rowley testified to finding violations of work done without a permit, and evidence was admitted supporting that fact. Additionally, Ms. Carlton continues to be in violation of this property, of not receiving a building permit. And so for these reasons, the city does feel that we have met the elements of this criminal complaint.
Okay. And defense, you get, I'll let defense have the last word on that.
Yes, Your Honor. There's been no allegations of any violations of any building code violations since the work stop order. There's been no work there, and there's been no proof of that. So there cannot be a continuing violation of the code. I would submit that in fact, you don't have a building permit, but you don't build. Is that a crime? That's the posture I would take, that there's no further crimes.
Thank you. And as to defense's motion for directed verdict, I'm going to deny that. I'm finding this is not beyond a reasonable doubt standard at this point. This is in the light most favorable to the prosecuting party, and that's the city. And so I believe there is sufficient evidence to move forward at this point. And so, defense, do you have a case to put on?
Yes, Your Honor.
Okay, and do you have a witness to call?
Yes, let me see.
Okay, do you know which witness you're going to be calling first? Okay. Why don't we all take a 5-minute break? We'll start at about 5 till 12. Or why don't we just start right at 12? And we'll give everybody a little bit of a break, and then we'll come back out. Okay, thank you.